All right. So hello. This is an first attempt to read for myself to read through the entire Canada, the Constitutional Acts of Canada. Don't know how far I'll get. I'm going to time myself so I keep myself to a undefined structure of reason. Maybe at most an hour and a half. I begin usually my recordings and documentation of my projects by marking the time and date. This is Thursday, January 27th, 2022 at 12:22 12 yes 1:22 at 22 hours. I'm reading the Canadian Constitutional Acts because I am frustrated with seeing the transformation of Canada, where I originally lived, and I've returned, but reluctantly, and got captured or caught. But anyway, the point is that I was watching the transformation of Canada from the 1990s until now, from the trajectory of Jean Chrétien and Paul Martin to Stephen Harper and, well, I mean, Stockwell Day and assorted others that were major contenders that failed. Michael Ignatieff and Stéphane Dion, and when Prime Minister Stephen Harper was really abusing let's just say, from the public that were criticizing him, he was being a bit abusive of his powers and just playing around with Canada as if it was his own little plaything. And he earned his boot. But I was working that night, October 2015, in the elections, and I was running I don't remember what I was doing. I think I was running a polling station, or I can't remember the title of it, but anyway, I was running something that was like a whole building, and I was the person to bring all the ballots back to the central office for the writing. And I was worried, that was 2015, and I was worried that Harper was going to, I presumed that he was going to lose. I think he had a majority then, but I thought he was going to go back down to a minority. At worst, he was going to lose entirely, and Trudeau was going to get in with a minority. It was a nightmare scenario. I mean, I didn't like Harper at all, but for numerous reasons. But I was hoping that he was reduced to a minority, and he would get his act together and think, okay, well, I got to be a little bit more holistic and supportive of everybody around, all the parties' interests. Unfortunately, Trudeau got in with a majority, which obliterated Stephen Harper quit immediately. And so, that's what they all do as soon as they lose. They just bail, generally. So Trudeau had his majority, which is just absolutely nightmarish. And then, of course, he did everything that he has done. All the violations that he's committed, and everybody, somehow his constituency, well, I mean, I understand that his constituency are more committed than they're more committed, and thus they're willing to turn a blind eye. And I think that's the general gist of the the Liberals in Canada. That goes for the provincial Liberals in Ontario as well. Like the provincial Liberals will defend their. I mean, I voted Liberal, so I know what it's like. But I quit. I'm not a Liberal voter anymore. But that's, I don't vote. I vote what I want to when I want to. I don't vote according to a party anymore. So, I mean, I don't think I can't remember who I voted for around the election when 2000 was it 2004 or 5, when Steve, I think it was 2004 or 5, or anywhere somewhere from 4 to 6, I can't remember, that Harper got in, defeated Stephen Martin. I don't remember if I voted that election. Anyway, point is that now Trudeau is far, far exceedingly worse than Harper ever was, but Trudeau's support base is just grind. Like he basically, of course he can't. Trudeau can't, like he doesn't gain support by. But anyway, I'm not going to do a commentary on my personal opinions other than just saying that I don't like him. And anybody can say they don't like any politician, but I just generally don't like any politicians. I'm more interested in seeing the country run well, and I mean, every politician does some good things for some people and does some really bad things for other people, and it's all an opinion. Generally, it comes down to opinions, and I think my opinions are fair for me, but they might not be fair for another person. And that makes me, of course, not liberal. That makes me an independent. And just by having my own opinions and thoughts, and being capable of independent thought, makes me ill or anti or non-capital L liberal in Canada these days. So, I'm going to read Canada's Constitution Acts, and we'll see where we get. The Constitution Act, here, this is the page at laws, L-O-I-S, law, justice.gc.ca, and const, page 1.html. The Constitution Acts, 1867 to 1982, and this is the page for the table of contents. Constitution Act. An act, I'm not sure how I'm going to read this, if I'll go through the footnotes. I may go through some of the end notes just for curiosity on the fly or interrupt, but I'll try to do it only when it's relevant. Constitution Act 1867. An act for the Union of Canada, Nova Scotia, and New Brunswick, and the government thereof, and for purposes connected therewith. Whereas the provinces of Canada, Nova Scotia, and New Brunswick have expressed their desire, capital D, desire to be federated under, or federally united into one dominion. I'm sorry, I'm also going to make some mistakes. I'm a little tired. I have drank a lot of coffee and I have more water here, but I'm going to carry on. Whereas these three parties have expressed their desire to be federally united under one dominion under the crown of the United Kingdom of Great Britain and Ireland, with a constitution similar in principle to that of the United Kingdom. And whereas such a union would conduce to the welfare of the provinces and promote the interests of the British Empire, and whereas on the establishment of the union by authority of Parliament, it is expedient not only that the constitution of the legislative authority in the Dominion be provided for, but also that the nature of the executive government therein be declared. And whereas it is expedient that provision be made for the eventual admission into the Union of other parts of British North America. Part 1, Preliminary. Short title, Section 1. This act may be cited as the Constitution Act, 1867. Section 2 repealed. Part 2, Union, Declaration of Union. Section 3. Now I'm going to possibly change how the format of me reading. I think I might go according to title as opposed to section, just so it makes sense. Or I don't know. I may go by sections every 10 or every 5 or something like that. Part 2, Union, Declaration of Union. It shall be lawful for the Queen and by and with the advice of Her Majesty's most honourable Privy Council to declare by proclamation that on and after a day therein appointed, not being more than 6 months after the passing of this act, the provinces of Canada, Nova Scotia, and New Brunswick shall form and be one Dominion under the name of Canada, and on and after that day, those 3 provinces shall form and be one Dominion under that name accordingly. Now, I'm just going to grab a tissue box. Yep, recorded myself. Keep myself comfortable. That's the Declaration of the Union. Next, construction of subsequent provisions of Act. Unless it is otherwise expressed or implied, the name Canada shall be taken to mean Canada as constituted under this Act. 4 provinces. Canada shall be divided into 4 provinces, named Ontario, Quebec, Nova Scotia, and New Brunswick. Provinces of Ontario and Quebec. The parts of the Province of Canada as it exists at the passing of this Act, which formerly constituted, respectively, the provinces of Upper Canada and Lower Canada, shall be deemed to be severed, and shall form 2 separate provinces. The part which formerly constituted the province of Upper Canada shall constitute the province of Ontario, and the part which formerly constituted the province of Lower Canada shall constitute the province of Quebec. Provinces of Nova Scotia and New Brunswick. The provinces of Nova Scotia and New Brunswick shall have the same limits as at the passing of this Act. Decennial Census. In the general census of the population of Canada, which is hereby required to be taken in the year 1871, and in every 10th year thereafter, the respective populations of the 4 provinces shall be distinguished. Part 3. Executive Power. Declaration of executive power in the Queen. The executive government and authority of and over Canada is hereby declared to continue and be vested in the Queen. Application of provisions referring to Governor General. The provisions of this Act referring to the Governor General extend and apply to the Governor General for the time being of Canada, and or other the Chief Executive Officer or Administrator for the time being, carrying on the government of Canada on behalf and in the name of the Queen by whatever title he is designated. Constitution of Privy Council for Canada. There shall be a privy There shall be a council to aid and advise in the government of Canada, to be styled the Queen's Privy Council for Canada. And the persons who are to be members of that council shall be from time to time chosen and summoned by the Governor-General and sworn in as privy councillors, and members thereof may be from time to time removed by the Governor-General. All powers under acts to be exercised by Governor-General and or with advice from of Privy Council or alone. All powers, authorities, and functions which under any act of the Parliament of Great Britain or of the Parliament of the United Kingdom of Great Britain and Ireland, or of the Legislature of Upper Canada, Lower Canada, Canada, Nova Scotia, or New Brunswick, are at the Union vested in or exercisable by the respective governors or lieutenant governors of those provinces, with the advice or with the advice and consent of the respective executive councils thereof, or in conjunction with those councils, or with any number of members thereof, or by those governors or lieutenant governors individually, shall, as far as the same continue in existence and capable of being exercised under or after the Union, in relation to the government of Canada, be vested in and exercisable by the Governor-General, with the advice, or with the advice and consent of, or in conjunction with, the Queen's Privy Council for Canada, or any members thereof, or by the Governor-General individually, as the case requires, subject, nevertheless, except with respect to such as exist under acts of the Parliament of Great Britain or of the Parliament of the United Kingdom or of Great Britain and Ireland, to be abolished or altered by the Parliament of Canada. Application of provisions referring to Governor-General in Council. The provisions of this Act referring to the Governor-General in Council shall be construed as referring to the Governor-General acting by and with the advice of the Queen's Privy Council for Canada. Power to Her Majesty to authorize Governor-General to appoint deputies. It shall be lawful for the Queen, if Her Majesty thinks fit, to authorize the Governor-General from time to time to appoint any person or any persons, jointly or severally, to be his deputy or deputies within any part or parts of Canada, and in that capacity to exercise during the pleasure of the Governor-General such of the powers, authorities, and functions of the Governor-General as the Governor-General deems it necessary or expedient to assign to him or them, subject to any limitations or directions expressed or given by the Queen. But the appointment of such a deputy or deputies shall not affect the exercise by the Governor-General himself of any power, authority, or function. Command of armed forces to continue to be vested in the Queen. The Command-in-Chief of the Land and Naval Militia and of all naval and military forces of and in Canada is hereby declared to continue and be vested in the Queen. Seat of Government of Canada. Until the Queen otherwise directs, The seat of the Government of Canada shall be Ottawa. Part 4. No, correction. That was the executive power, Part 3. Now on to Part 4. Legislative power. Constitution of Parliament of Canada. There shall be one Parliament for Canada, consisting of the Queen, an upper house styled the Senate, and the House of Commons. Privileges, etc., of the houses. The privileges, immunities, and powers to be held, enjoyed, and exercised by the Senate and by the House of Commons and by the members thereof, respectively, shall be such as are from time to time defined by Act of the Parliament of Canada, but so that any Act of the Parliament of Canada defining such privileges, immunities, and powers shall not confer any privileges, immunities, or powers exceeding those at the passing of such Act, held, enjoyed, and exercised by the Commons House of Parliament of the United Kingdom of Great Britain and of Ireland, and by the members thereof. It's like a carbon copy of, yeah. First session of the Parliament of Canada. The Parliament of Canada shall be called together not later than 6 months after the Union. The Senate. Number of senators. The Senate shall, subject to the provisions of this Act, consist of 105 members, who shall be styled senators. Representation of provinces in Senate. In relation to the Constitution of the Senate of Canada, in relation to the Constitution of the Senate, Canada shall be deemed to consist of 4 divisions. Ontario, Quebec, the Maritime Provinces, Nova Scotia and New Brunswick and Prince Edward Island, the Western Provinces of Manitoba, British Columbia, Saskatchewan, and Alberta, which 4 divisions shall, subject to the provisions of this Act, be equally represented in the Senate as follows: Ontario by 24 senators, Quebec by 24 senators, the Maritime Provinces and Prince Edward Island by 24 senators, 10 thereof representing Nova Scotia, 10 thereof representing New Brunswick, and 4 thereof representing Prince Edward Island. The Western Provinces by 24 senators, 6 thereof representing Manitoba, 6 thereof representing British Columbia, 6 thereof representing Saskatchewan, and 6 thereof representing Alberta. Newfoundland shall be entitled to be represented in the Senate by 6 members. The Yukon Territory, the Northwest Territories, and Nunavut shall be entitled to be represented in the Senate by 1 member each. In the case of Quebec, each of the 24 senators representing that province shall be appointed for 1 of the 24 electoral divisions of Lower Canada specified in Schedule A to Chapter 1 of the Consolidated Statutes of Canada. Qualifications of senator. The qualifications of a senator may be as follows. He shall be of the full age of 30 years. He shall be either a natural born subject of the Queen or a subject of the Queen naturalized by an act of the Parliament of Great Britain or of the Parliament of the United Kingdom of Great Britain and Ireland, or of the legislature of one of the provinces of Upper Canada, Lower Canada, Canada, Nova Scotia, or New Brunswick before the Union, or of the Parliament of Canada after the Union. He shall be legally or equitably seized as of freehold for his own use and benefit of lands or tenements held in free and common usage, or seized of or possessed for his own use and benefit of lands or tenements held in franc élu or in roture within the province for which he is appointed, of the value of $4,000 over and above all rents, dues, debts, charges, mortgages, and encumbrances due or payable out of or charged on or affecting the same. His real and personal property shall be together worth $4,000 over and above his debts and liabilities. He shall be resident in the province for which he is appointed. In the case of Quebec, he shall have his real property qualification in the electoral division for which he is appointed, or shall be resident in that division. Summons of a senator. The Governor-General shall from time to time, in the Queen's name, by instrument under the Great Seal of Canada, summon qualified persons to the Senate, and, subject to the provisions of this Act, every person so summoned shall become and be a member of the Senate and a senator. Addition of senators in certain cases. If at any time on the recommendation of the Governor-General, the Queen thinks fit to direct that 4 or 8 members be added to the Senate, the Governor-General may by summons to 4 or 8 qualified persons, as the case may be, representing equally the 4 divisions of Canada, add to the Senate accordingly. Reduction of Senate to normal number. In case of such addition being at any time made, the Governor-General shall not summon any person to the Senate, except on a further like direction by the Queen, on the like recommendation, to represent one of the 4 divisions, until such division is represented by 24 senators and no more. Maximum number of senators. The number of senators shall not at any time exceed 113. Tenure of place in Senate. 1. Subject to subsection 2, a senator shall, subject to the provisions of this Act, hold his place in the Senate for life. Retirement upon attaining age of 75 years, subsection 2. A senator who is summoned to the Senate after the coming into force of this subsection shall, subject to this Act, hold his place in the Senate until he attains the age of 75 years. Resignation of place in Senate. A senator may, by writing under his hand addressed to the Governor-General, resign his place in the Senate, and thereupon the same shall be vacant. Disqualification of senators. The place of a senator shall become vacant in any of the following cases. If for 2 consecutive sessions of Parliament he fails to give his attendance in the Senate. If he takes an oath or makes a declaration or acknowledgement of allegiance, obedience, or adherence to a foreign power, or does an act whereby he becomes a subject or citizen or entitled to rights or privileges of a subject or citizen of a foreign power, if he is adjudged bankrupt or insolvent or applies for the benefit of any law relating to insolvent debtors or becomes a public defaulter, if he is attainted of treason or convicted of felony or of any infamous crime, if he ceases to be qualified in respect of property or of residence, provided that a senator shall not be deemed to have ceased to be qualified in respect of residence by reason only of his residing at the seat of the Government of Canada while holding an office under the government requiring his presence there. Summons on vacancy in Senate. When a vacancy happens in the Senate, by resignation, death, or otherwise, the Governor General shall by summons to a fit and qualified person fill the vacancy. Questions as to qualifications and vacancies in Senate. If any question arises respecting the qualification of a senator or a vacancy in the Senate, the same shall be heard and determined by the Senate. Appointing of Speaker of Senate. The Governor General may from time to time, by instrument under the Great Seal of Canada, appoint a senator to be Speaker of the Senate and may remove him and appoint another in his stead. Quorum of Senate. Until the Parliament of Canada otherwise provides, the presence of at least 15 senators, including the Speaker, shall be necessary to constitute a meeting of the Senate for the exercise of its powers. Voting in the Senate. Questions arising in the Senate shall be decided by a majority of voices, and the Speaker shall in all cases have a vote. And when the voices are equal, the decision shall be deemed to be in the negative. The House of Commons. Constitution of House of Commons in Canada. The House of Commons shall, subject to the provisions of this Act, consist of 308 members, of whom 106 shall be elected for Ontario, 75 for Quebec, 11 for Nova Scotia, 10 for New Brunswick, 14 for Manitoba, 36 for British Columbia, 4 for Prince Edward Island, 28 for Alberta, 14 for Saskatchewan, 7 for Newfoundland, 1 for Yukon Territory, 2 for Northwest Territories, and 1 for Nunavut. Summoning of House of Commons. The Governor General shall, from time to time, in the Queen's name, by instrument under the Great Seal of Canada, summon and call together the House of Commons. Senators not to sit in House of Commons. A senator shall not be capable of being elected or of sitting or voting as a member of the House of Commons. Electoral districts of the 4 provinces. Until the Parliament of Canada otherwise provides, Ontario, Quebec, Nova Scotia, and New Brunswick shall, for the purposes of the election of members to serve in the House of Commons, be divided into electoral districts as follows. Ontario. Ontario shall be divided into the counties, ridings of counties, cities, parts of cities, and towns enumerated in the first schedule to this Act, each whereof shall be an electoral district, each such district as numbered in that schedule being entitled to return 1 member. Quebec shall be divided into 65 electoral districts composed of the 65 electoral divisions into which Lower Canada is, at the passing of this Act, divided under Chapter 2 of the Consolidated Statutes of Canada, Chapter 75 of the Consolidated Statutes of Lower Canada, and the Act of the Province of Canada of the 23rd year of the Queen, Chapter 1, or any other act amending the same in force at the Union, so that each electoral division shall be, for the purposes of this act, an electoral district, entitled to return one member. Nova Scotia. Each of the 18 counties of Nova Scotia shall be an electoral district. The county of Halifax shall be entitled to return 2 members, and each of the other counties 1 member. New Brunswick. Each of the 14 counties into which New Brunswick is divided, including the city and county of St. John, shall be an electoral district. The city of St. John shall also be a separate electoral district. Each of those 15 electoral districts shall be entitled to return 1 member. There is a note here. Note 21 for New Brunswick. Spent. The electoral districts are now established by proclamations issued from time to time under the Electoral Boundaries Readjustment Act, 1985. All right. They've been spent. Oh, and I just went back a bit. Oh, look at that. Continuance of existing election laws until Parliament of Canada otherwise provides. Until the Parliament of Canada otherwise provides, all laws in force in the several provinces at the Union relative to the following matters, or any of them, namely the qualifications and disqualifications of persons to be elected or to sit or vote as members of the House of Assembly or Legislative Assembly in the several provinces, the voters at elections of such members, the oaths to be taken by voters, the returning officers, their powers and duties, the proceedings at elections, the periods during which elections may be continued, the trial of converted elections, the proceedings incident thereto, the vacating of seats of members, and the election of new writs in case of seats vacated otherwise than by dissolution, shall respectively apply to elections of members to serve in the House of Commons for the same purpose, several provinces. Provided that until the Parliament of Canada otherwise provides, at any election for a member of the House of Commons for the District of Algoma, in addition to persons qualified by the law of the Province of Canada to vote, every male British subject aged 21 years or upwards, being a householder, shall have a vote. Well, that's interesting. As to election of Speaker of House of Commons, the House of Commons, on its first assembling after a general election, shall proceed with all practicable speed to elect one of its members to be Speaker. As to filling up vacancy in office of Speaker, In case of a vacancy happening in the office of Speaker by death, resignation, or otherwise, the House of Commons shall, with all practicable speed, proceed to elect another of its members to be Speaker. Speaker to preside. The Speaker shall preside at all meetings of the House of Commons. Provision in case of absence of Speaker. Until the Parliament of Canada otherwise provides, in case of the absence for any reason of the Speaker from the Chair of the House of Commons for a period of 48 consecutive hours, the House may elect another of its members to act as Speaker, and the member so elected shall, during the continuance of such absence of the Speaker, have and execute all the powers, privileges, and duties of the Speaker. Quorum of House of Commons. The presence of at least 20 members of the House of Commons shall be necessary to constitute a meeting of the House for the exercise of its powers, and for that purpose the Speaker shall be reckoned as a member. Now I have read, it is now 1:03, it's been about half an hour, I believe. .40 We have finished the first of 48 pages. Yep. Although, here we find, wait a minute, pardon me, that's not the first of 48 pages. That's the first one through, that was page, or that was the page that represents sections 1 through 48. We have read approximately 1/3 of the Constitution, excluding these additional schedules. All right, let's carry on. Now, this goes to 90. I'm going to switch up format, or at least try. This is the continuing of the part for legislative power on the section for the sub-part for the House of Commons. I'm going to read the titles quicker in a different voice. Voting in House of Commons. Questions arising in the House of Commons shall be decided by a majority of voices other than that of the Speaker, and when the voices are equal but not otherwise, the Speaker shall have a vote. Duration of House of Commons. Every House of Commons shall continue for 5 years from the day of the return of the writs for choosing the House, subject to be sooner dissolved by the Governor-General, and no longer. Readjusting of representation in Commons. The number of members of the House of Commons and the representation of the provinces therein shall, on the completion of each decennial census, be readjusted by such authority in such manner and from such time as the Parliament of Canada provides from time to time, subject and according to the following rules. 1. There shall be assigned to each of the provinces a number of members equal to the number obtained by dividing the population of the province by the electoral quotient and rounding up any fractional remainder to 1. If the number of members assigned to a province by the application of Rule 1 and Section 51A is less than the total number assigned to that province on the date of the coming into force of the Constitution Act 1985 representation, there shall be added to the number of members so assigned such number of members as will result in the province having the same number of members as were assigned on that date. After the application of Rules 1 and 2 and Sections 51A, there shall, this is 51, by the way, this section that I am reading is with the rules is Section 51. Now, which is 51A is specifically down below, and I will interject that now. 51A, Constitution of House of Commons. Notwithstanding anything in this Act, a province shall always be entitled to a number of members in the House of Commons not less than the number of senators representing each such province. So it attaches senators as a minimum, the count of senators at a minimum. After the application of Rules 1 and 2 and Section 51A, there shall, in respect of each province that meets the condition set out in Rule 4, to be read next, be added, if necessary, a number of members such that, on the completion of the readjustment, the number obtained by dividing the number of members assigned to that province by the total number of members assigned to all the provinces is as close as possible to, without being below, the number obtained by dividing the population of that province by the total population of all provinces. This is now Rule 4. Rule 3 applies to a province if, on the completion of the preceding readjustment, the number obtained by dividing the number of members assigned to that province by the total number of members assigned to all the provinces was equal to or greater than the number obtained by dividing the population of that province by the total population of all the provinces, the population of each province being its population as at July 1 of the year of the decennial census that preceded that readjustment, according to the estimates prepared for the purpose of that readjustment. According to the purpose, the estimates prepared for the purpose. Unless Rule 5, unless the context indicates otherwise, in these rules, the population of a province is the estimate of its population as at July 1 of the year of the most recent decennial census. Rule 6. In these rules, electoral quotient means A. 111,166 in relation to the readjustment following the completion of the 2011 decennial census, and B. in relation to the readjustment following the completion of any subsequent decennial census, the number obtained by multiplying the electoral quotient that was applied in the preceding readjustment by the number that is the average of the numbers obtained by dividing the population of each province by the population of the province as at July 1 of the year of the preceding decennial census, according to the estimates prepared for the purpose of the preceding readjustment, and rounding up any fractional remainder of that multiplication to 1. We are done with the rules for readjustments of representation in Commons. Next, we go to subsection 1.1, 51, subsection 1.1. Population estimates. For the purpose of the rules in subsection 1, there is required to be prepared an estimate of the population of Canada and of each province as at July 1, 2001 and July 1, 2011, and in each year following the 2011 decennial census in which a decennial census is taken as at July 1 of that year by such authority in such manner and from such time as the Parliament of Canada provides from time to time. Yukon Territory, Northwest Territories, and Nunavut. This is subsection 2 of section 51. The Yukon Territory, as bounded and described in the schedule to Chapter Y2 of the Revised Statutes of Canada, 1985, shall be entitled to one member. The Northwest Territories, as bounded and described in Section 2 of Chapter N27 of the Revised Statutes of Canada, 1985, as amended by Section 77 of Chapter 28 of the Statutes of Canada, 1993, shall be entitled to one member, and Nunavut, as bounded and described in Section 3 of Chapter 28 of the Statutes of Canada, 1993, shall be entitled to one member. Constitution of House of Commons. Section 51A. Notwithstanding anything in this Act, a province shall always be entitled to a number of members in the House of Commons not less than the number of senators representing such province. That's what I read a few minutes ago, but continuing. This is Section 52. Increase of number of House of Commons. The number of members of the House of Commons may be, from time to time, increased by the Parliament of Canada, provided the proportionate representation of the provinces prescribed by this Act is not thereby disturbed. Money votes, royal assent. This remains part of Part 4 legislative power, but has now concluded the House of Commons and is continuing. Money votes, royal assent. Appropriation and tax bills. Bills for appropriating any part of the public revenue or for imposing any tax or impost shall originate in the House of Commons. Recommendation of money votes. It shall not be lawful for the House of Commons to adopt or pass any vote, resolution, address, or bill for the appropriation of any part of the public revenue or of any tax or impost to any purpose that has not been first recommended to that House by message of the Governor General in the session in which such vote, resolution, address, or bill is proposed. Royal assent to bills. Where a bill passed by the Houses of the Parliament is presented to the Governor General for the Queen's assent, he shall declare, according to his discretion, but subject to the provisions of this Act and to Her Majesty's instructions, either that he assents thereto in the Queen's name, or that he withholds the Queen's assent, or that he reserves the bill for the signification of the Queen's pleasure. Disallowance by order in Council of Act assented to by Governor General. Where the Governor General assents to a bill in the Queen's name, he shall, by the first convenient opportunity, send an authentic copy of the Act to one of Her Majesty's principal Secretaries of State, and if the Queen in Council within 2 years after the receipt thereof by the Secretary of State, thinks fit to disallow the act, such disallowance, with a certificate of the Secretary of State of the day on which the act was received by him, being signified by the Governor General by speech or message to each of the houses of the Parliament or by proclamation, shall annul the act from and after the day of such signification. Signification of Queen's pleasure on bill reserved. A bill reserved for the signification of the Queen's pleasure shall not have any force unless and until within 2 years from the day on which it was presented to the Governor General for the Queen's assent, the Governor General signifies by speech or message to each of the houses of the Parliament or by proclamation that it has received the assent from the Queen in Council, or of the Queen in Council. An entry of each such speech, message, or proclamation shall be made in the journal of each house, and a duplicate thereof, duly attested, shall be delivered to the proper officer to be kept among the records of Canada. The records of Canada. 5. Provincial Constitutions. This is Part 5 or Chapter 5, Provincial Constitutions. Chapter, I guess it's better to call this chapter as opposed to part. Chapter 5, Provincial Constitutions. Major section, Executive Power. Appointment of lieutenant generals, lieutenant governors of provinces. For each province there shall be an officer styled the lieutenant governor, appointed by the Governor General in Council by instrument under the Great Seal of Canada. Tenure of office of lieutenant governor. A lieutenant governor shall hold office during the pleasure of the Governor General, but any lieutenant governor appointed after the commencement of the first session of the Parliament of Canada shall not be removable within 5 years of his appointment, except for cause assigned, which shall be communicated to him in writing within 1 month after the order for his removal is made, and shall be communicated by message to the Senate and to the House of Commons within 1 week thereafter, if the Parliament is then sitting, and if not, then within 1 week after the commencement of the next session of the Parliament. Salaries of Lieutenant Governors. The salaries of the Lieutenant Governors shall be fixed and provided by the Parliament of Canada. Oaths, etc., of Lieutenant Governor. Every Lieutenant Governor shall, before assuming the duties of his office, make and subscribe, before the Governor General or some person authorized by him, oaths of allegiance and office, similar to those taken by the Governor General. Application of provisions referring to Lieutenant Governor. The provisions of this Act referring to the Lieutenant Governor extend and apply to the Lieutenant Governor for the time being of each province, or other the Chief Executive Officer or Administrator for the time being carrying on the government of the province by whatever title he is designated. Appointment of executive officers for Ontario and Quebec. The Executive Council of Ontario and of Quebec shall be composed of such persons as the Lieutenant Governor from time to time thinks fit, and in the first instance of the following officers, namely, the Attorney General, the Secretary and Registrar of the Province, the Treasurer of the Province, the Commissioner of Crown Lands, and the Commissioner of Agriculture and Public Works, in Quebec, the Speaker of the Legislative Council and the Solicitor General. Executive Government of Nova Scotia and New Brunswick. The constitution of the executive authority in each of the provinces of Nova Scotia and New Brunswick shall, subject to the provisions of this Act, continue as it exists at the Union until altered under the authority of this Act. Powers to be exercised by Lieutenant Governor of Ontario or Quebec with advice or alone. All powers, authorities, and functions which under any act of the Parliament of Great Britain or of the Parliament of the United Kingdom of Great Britain and Ireland, or of the Legislature of Upper Canada, Lower Canada, or Canada, were or are before or at the Union, vested in or exercisable by the respective governors or lieutenant governors of those provinces with the advice and consent of the respective executive councils thereof, or in conjunction with those councils, or with any number of members thereof, or by those governors or lieutenant governors individually, shall, as far as the same are capable of being exercised after the Union in relation to the government of Ontario and Quebec respectively, be vested in and shall or may be exercised by the Lieutenant Governor of Ontario and Quebec respectively with the advice and consent of or in conjunction with the respective executive councils or any members thereof, or by the Lieutenant Governor individually as the case requires, subject nevertheless, except with respect to such as exist under Acts of Parliament of Great Britain or of the Parliament of the United Kingdom of Great Britain and Ireland, to be abolished or altered by the respective legislatures of Ontario and Quebec. Application of provisions referring to Lieutenant Governor in Council. The provisions of this Act referring to the Lieutenant Governor in Council shall be construed as referring to the Lieutenant Governor of the province acting by and with the advice of the Executive Council thereof. Administration in absence, et cetera, of Lieutenant Governor. I'm switching to say et cetera instead of et cetera. That's the proper pronunciation. Always everybody says et cetera. The Governor General and Council may from time to time appoint an administrator to execute the office and functions of Lieutenant Governor during his absence, illness, or other inability. Seats of provincial governments. Unless and until the executive government of any province otherwise directs with respect to that province, the seats of government of the provinces shall be as follows, namely, of Quebec, of Ontario, the City of Toronto; of Quebec, the City of Quebec; of Nova Scotia, the City of Halifax; and of New Brunswick, the City of Fredericton. Major subchapter, legislative power. We have now concluded executive power under provincial constitutions, and we are continuing with legislative power. 1. Ontario. The legislature for Ontario. There shall be a legislature for Ontario, consisting of the Lieutenant Governor and of one House, styled the Legislative Assembly of Ontario. Electoral districts. The Legislative Assembly of Ontario shall be composed of 82 members to be elected to represent the 82 electoral districts set forth in the first schedule to this Act. Under legislative power, Chapter 2, Quebec. Legislature for Quebec. There shall be a legislature for Quebec consisting of the Lieutenant Governor and of two houses, styled the Legislative Council of Quebec and the Legislative Assembly of Quebec. Constitution of Legislative Council. The Legislative Council of Quebec shall be composed of 24 members to be appointed by the Lieutenant Governor in the Queen's name by instrument under the Great Seal of Quebec, one being appointed to represent each of the 24 electoral divisions of Lower Canada in this Act referred to, and each holding office for the term of his life under the legislature of Quebec, unless the legislature of Quebec otherwise provides under the provisions of this Act. Qualification of legislative councillors. The qualifications of legislative councillors of Quebec shall be the same as those of the senators for Quebec. Resignation, disqualification, etc. The place of a legislative councillor of Quebec shall become vacant in the cases mutatis mutandis, in which the place of senator becomes vacant. Vacancies. When a vacancy happens in the Legislative Council of Quebec, by resignation, death, or otherwise, the Lieutenant Governor, in the Queen's name, by instrument under the Great Seal of Quebec, shall appoint a fit and qualified person to fill the vacancy. Questions as to vacancies, etc. If any question arises respecting the qualification of a legislative councillor of Quebec, or a vacancy in the Legislative Council of Quebec, the same shall be heard and determined by the Legislative Council. Speaker of Legislative Council. The Lieutenant Governor may, from time to time, be, by instrument under the Great Seal of Quebec, appoint a member of the Legislative Council of Quebec to be Speaker thereof, and may remove him and appoint another in his stead. Quorum of Legislative Council. Until the Legislature of Quebec otherwise provides, the presence of at least 10 members of the Legislative Council, including the Speaker, shall be necessary to constitute a meeting for the exercise of its powers. Voting in Legislative Council. Questions arising in the Legislative Council of Quebec shall be decided by a majority of voices, and the Speaker shall in all cases have a vote, and when the voices are equal, the decision shall be deemed to be in the negative. Constitution of Legislative Assembly of Quebec. The Legislative Assembly of Quebec shall be composed of 65 members to be elected to represent the 65 electoral divisions or districts of Lower Canada in this Act, referred to, subject to alteration thereby by the Legislature of Quebec, provided that it shall not be lawful to present to the Lieutenant Governor of Quebec for assent any bill for altering the limits of any of the electoral districts or districts mentioned in the second schedule of this Act, unless the second and third readings of such bill have been passed in the Legislative Assembly, with the concurrence of the majority of the members representing all the electoral divisions or districts, and the assent shall not be given to such bill unless an address has been presented by the Legislative Assembly to the Lieutenant Governor stating that it has been so passed. Under legislative power, subchapter 3, following subchapters 1 and 2, Ontario and Quebec respectively. Subchapter 3, Ontario and Quebec. Summoning of legislative assemblies. The Lieutenant Governor of Ontario and Quebec shall from time to time, in the Queen's name, by instrument under the Great Seal of the province, summon and call together the Legislative Assembly of the province. Restriction on election of holders of offices. Until the Legislature of Ontario and Quebec otherwise provides, a person accepting or holding in Ontario or in Quebec any office, commission, or employment, permanent or temporary, at the nomination of the Lieutenant Governor, to which an annual salary or any fee, allowance, emolument, or profit of any kind or amount, whatever, from the province is attached, shall not be eligible as a member of the legislative assembly of the respective province, nor shall he sit or vote as such. But nothing in this section shall make illegible any person being a member of the executive council of the respective province, or holding any of the following offices, that is to say, the offices of Attorney General, Secretary and Registrar of the province, Treasurer of the province, Commissioner of Crown Lands, and Commissioner of Agriculture and Public Works, and in Quebec, Solicitor General, or shall disqualify him to sit or vote in the House for which he is elected, provided he is elected while holding such office. Continuance of existing election laws. Until the legislatures of Ontario and Quebec, respectively, otherwise provide, all laws which at the Union are in force in those provinces, respectively, relative to the following matters, or any of them, namely, the qualifications and disqualifications of persons to be elected or to sit or vote as members of the Assembly of Canada, the qualifications and disqualifications of members, the oaths to be taken by voters, the returning officers, their powers and duties, the proceedings at elections, the periods during which such elections may be continued, and the trial of controverted elections, and the proceedings incident thereto, the vacating of seats of members, and the issuing of execution of new writs in case of seats vacated otherwise than by dissolution, shall respectively apply to elections of members to serve in the respective legislative assemblies of Ontario and Quebec, provided that until the legislature of Ontario otherwise provides, at any election for a member of the Legislative Assembly of Ontario for the District of Algoma, in addition to persons qualified under the law of the Province of Canada to vote, every male British subject aged 21 years or upwards, being a householder, shall have a vote. Duration of legislative assemblies. Every legislative assembly of Ontario and every legislative assembly of Quebec shall continue for 4 years from the day of the return of the writs for choosing the same, subject nevertheless to either the Legislative Assembly of Ontario or of the Legislative Assembly of Quebec being sooner dissolved by the Lieutenant Governor of the province, and no longer. Yearly session of legislature. Yearly session of legislature. There shall be a session of the legislature of Ontario and of that of Quebec, once, at least, in every year, so that 12 months shall not intervene between the last sitting of the legislature in each province in one session and its first sitting in the next session. Speaker quorum, etc. The following provisions of this Act, respecting the House of Commons of Canada, shall extend and apply to the legislative assemblies of Ontario and Quebec, that is to say, the provisions relating to the election of a Speaker originally and on vacancies, the duties of the Speaker, the absence of the Speaker, the quorum, and the mode of voting, as if those provisions were here reenacted and made applicable in terms to each such legislative assembly. Subchapter 4. Chapter 4, subchapter 4. Oh, wait a minute. This is chapter, yes, legislative powers. The subchapter being legislative power. The subchapter is for Nova Scotia and New Brunswick. Constitutions of legislatures of New Brunswick, or Nova Scotia and New Brunswick. The Constitution of the legislature of each of the provinces of Nova Scotia and New Brunswick shall, subject to the provisions of this Act, continue as it exists at the Union until altered under the authority of this Act. Subchapter 5. Ontario, Quebec, and Nova Scotia. The only section herein was repealed. Subchapter 6. The 4 provinces. Application to legislatures of provisions respecting money votes, etc. The following provisions of this Act respecting the Parliament of Canada, namely, the provisions relating to appropriation and tax bills, the recommendation of money votes, the assent to bills, the disallowance of acts, and the signification of pleasure on bills reserved, shall extend and apply to the legislatures of the several provinces as if those provinces were here reenacted and made applicable in terms to the respective provinces and the legislatures thereof, with the substitution of the Lieutenant Governor of the province for the Governor General, of the Governor General for the Queen, and for a Secretary of State of 1 year or for 2 years, and of the province of Canada. Going on, we have now reached the end of section 90. In chapter 4, we are currently in chapter 4, legislative powers. The subchapter, wait a minute, 5. We are under Oh, pardon me. I think I made a mistake in my preceding the chapter definition. We at some point had been in Provincial Constitutions, and I was okay. So we were in Chapter 5, Subchapter Executive Power. Next is Subchapter Legislative Power, and we've just concluded with Subchapter 6, the 4 provinces. Now, and we have reached Section 90 of the Constitution. Continuing to the next page of content. We are in Chapter 6 of the Constitution. Yes. Subchapter Powers of the Parliament. Legislative authority of Parliament of Canada. It shall be lawful for the Queen, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada in relation to all matters not coming within the classes of subjects by this Act, assigned exclusively to the legislatures of the provinces, and for greater certainty, but not so as to restrict the generality of the foregoing terms of this section, it is hereby declared that, notwithstanding anything in this Act, the executive legislature authority of the Parliament of Canada extends to all matters coming within the classes of subjects next hereinafter enumerated. That is to say, 1. Repealed. 1A. The public debt and property. 2. The regulation of trade and commerce. 2A. Unemployment insurance. 3. The raising of money by any mode or system of taxation. 4. The borrowing of money on the public credit. 5. Postal service. 6. The census and statistics. 7. Militia, military, and naval service and defense. 8. The fixing of and providing for the salaries and allowances of civil and other officers of the Government of Canada. 9. Beacons, buoys, lighthouses, and Sable Island. 10. Navigation and shipping. 11. Quarantine and the establishment and maintenance of marine hospitals. 12. Sea coast and inland fisheries. 13. Ferries between a province and any British or foreign country or between two provinces. 14. Currency and coinage. 15. Banking, incorporation of banks and the issue of paper money. 16. Savings banks. 17. Weights and measures. 18. Bills of exchange and promissory notes. 19. Interest. 20. Legal tender. 21. Bankruptcy and insolvency. 22. Patents of invention and discovery. 23. Copyrights. 24. Indians and lands reserved for the Indians. 25. Naturalization and aliens. 26. Marriage and divorce. 27. The criminal law, except the constitution of courts of criminal jurisdiction, but including the procedure in criminal matters. 28. The establishment, maintenance, and management of penitentiaries. 29. Such classes of subjects as are expressly accepted in the enumeration of the classes of subjects by this Act, assigned exclusively to the legislatures of the provinces. And any matter coming within any of the classes of subjects enumerated in this section shall not be deemed to come within the class of matters of a local or private nature comprised in the enumeration of the classes of subjects by this Act, assigned exclusively to the legislatures of the provinces. Subchapter Exclusive Powers of Provincial Legislatures. Subjects of exclusive provincial legislature. In each province, the legislature may be exclusively in each province, the legislature may exclusively make laws in relation to matters coming within the classes of subjects next hereinafter enumerated. That is to say, 1. Repealed. End note 48, possibly to be read later. Pardon me. Let's check that out. End note 48, number 1, repealed. Added, 48. Class 1 was repealed by the Constitution Act 1982. As enacted, it read as follows. 1. The amendment from time to time, notwithstanding anything in this Act, of the Constitution of the province, except as regards the office of the Lieutenant General, Governor. The amendment from time to time, notwithstanding anything in this Act, of the Constitution of the province, except as regards the office of the Lieutenant Governor. Right. Returning to section 92 under subchapter Exclusive Powers of Provincial Legislatures. The subjects of exclusive provincial legislation. 2. The enumeration of classes that are classes of subjects for exclusive dominion under the province of legislature, provincial legislatures. 2. Direct taxation within the province in order to the raising of a revenue for provincial purposes. 3. The borrowing of money on the sole credit of the province. 4. The establishment and tenure of provincial offices and the appointment and payment of provincial officers. 5. The management and sale of the public lands belonging to the province and of the timber and wood thereon. 6. The establishment, maintenance, and management of public and reformatory prisons in and for the province. 7. The establishment, maintenance, and management of hospitals, asylums, charities, and eleemosynary institutions in and for the province, other than marine hospitals. 8. Municipal institutions in the province. 9. Shop, saloon, tavern, auctioneer, and other licenses in order to the raising of a revenue for provincial, local, or municipal purposes. 10. Local works and undertakings other than such as are of the following classes. A. Lines of steam or other ships, railways, canals, telegraphs, and other works and undertakings connecting the province with any other or others of the provinces, or extending beyond the limits of the province. B. Lines of steam ships between the province and any British or foreign country. C. Such works as, although wholly situate within the province, are before or after their execution declared by the Parliament of Canada to be for the general advantage of Canada, or for the advantage of 2 or more provinces. 11. The incorporation of companies within provincial objects. 12. The solemnization of marriage in the province. 13. Property and civil rights in the province. 14. The administration of justice in the province, including the constitution, maintenance, and organization of provincial courts, both of civil and of criminal jurisdiction, and including procedure in civil matters in those courts. 15. The imposition of punishment by fine, penalty, or imprisonment for enforcing any law of the province made in relation to any matter coming within any of the classes of subjects enumerated in this section. 16. Generally all matters of a merely local or private nature in the province. Subchapter: Non-renewable natural resources, forestry resources, and electrical energy. Laws respecting non-renewable natural resources, forestry resources, and electrical energy. This is now section 92A, an extension of 92, which was a separate preceding subchapter, the exclusive power of provincial legislatures. Laws respecting non-renewable natural resources, forestry resources, and electrical energy. 92A. Subsection 1. In each province, the legislature may exclusively make laws in relation to A. Exploration for non-renewable natural resources in the province. B. Development, conservation, and management of non-renewable natural resources and forestry resources in the province, including laws in relation to the rate of primary production therefrom. And C. Development, conservation, and management of sites and facilities in the province for the generation and production of electrical energy. Export from provinces of resources. Subsection 92A, subsection 2. In each province, the legislature may make laws in relation to the export from the province to another part of Canada of the primary production from non-renewable natural resources and forestry resources in the province, and the production from facilities in the province for the generation of electrical energy, but such laws may not authorize or provide for discrimination in prices or in supplies exported to another part of Canada. Authority of Parliament. Subsection 3. 92A, subsection 3. Nothing in subsection 2 derogates from the authority of Parliament to enact laws in relation to the matters referred to in that subsection, and where such a law of Parliament and a law of a province conflict, the law of Parliament prevails to the extent of the conflict. Taxation of resources. 92A, subsection 4. In each province, the legislature may make laws in relation to the raising of money and by any mode or system of taxation in respect of A. non-renewable natural resources and forestry resources in the province, and the primary production therefrom, and B. sites and facilities in the province for the generation of electrical energy and the production therefrom. Whether or not such production is exported in whole or in part from the province. But such laws may not authorize or provide for taxation that differentiates between the production exported to another part of Canada and production not exported from the province. Primary production. 92A, subsection 5. The expression primary production has the meaning assigned by the 6th schedule. I'm just deciding right now if I'm going to jump to the 6th schedule, because that is a direct inclusion. The primary production. I am on page 3, subsection 92A.5, the 6th schedule, primary production. Let's go take a look. Primary production from non-renewable resources and forestry resources. Here we go. This is the 6th schedule. The primary production from non-renewable natural resources and forestry resources. 1. For the purposes of section 92A of this Act, A. Production from a non-renewable natural resource is primary production therefrom if I, or that's Roman numeral 1, or it's I, let's just say I. It is in the form of, it is, I'm just going to say 1 because that is the Roman numeral for 1. It is in the form in which it exists upon its recovery or severance from its natural state. Or 2, it is a product resulting from processing or refining the resource and is not a manufactured product or a product resulting from refining crude oil, refining in upgraded heavy crude oil, refining gases or liquids derived from coal, or refining a synthetic equivalent of crude oil, and B. Production from a forestry resource is primary production therefrom if it consists of saw logs, poles, lumber, wood chips, sawdust, or any other primary wood product or wood pulp, and is not a product manufactured from wood. That's a bit confusing. Production from a forestry resource is primary production therefrom if it consists of saw logs, poles, blah, 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 and is, or wood pulp. For the purposes of 1986, production from non-renewable is primary. Production from a forest resource is primary production therefrom if it consists of saw logs, poles, lumber, wood chips, sawdust, or any other primary wood product or wood pulp, and is not a product manufactured from wood. Not really sure how to process that, but it's okay. We basically get it. So here we go. Going back to 92A, subsection 5. The expression primary production has the meaning assigned. So it's basically an I don't know why they didn't just drop it in there. Okay, existing powers or rights. 92A, subsection 6. Nothing in subsections 1 to 5 derogates from any powers or rights that a legislature or government of a province had immediately before the coming into force of this section. Subchapter Education. Legislation respecting education. In and for each province, the legislature may exclusively make laws in relation to education, subject, and according to the following provisions. 1. Nothing in any such law shall prejudicially, I had it right the first time, affect any right or privilege with respect to denominational schools, which any class of persons have by law in the province at the Union. 2. All the powers, privileges, and duties at the Union by law conferred and imposed in Upper Canada on the separate schools and school trustees of the Queen's Roman Catholic subjects shall be, and the same are hereby extended to the dissentient schools of the Queen's Protestant and Roman Catholic subjects in Quebec. 3. Where in any province a system of separate or dissentient schools exists by law at the Union or is thereafter established by the legislature of the province, an appeal shall lie to the Governor General in Council and from any act or decision of any provincial authority affecting any right or privilege of the Protestant or Roman Catholic minority of the Queen's subjects in relation to education. In case any such provincial law, as from time to time seems to the Governor General in Council requisite for the due execution of the provisions of this section, is not made, or in case any decision of the Governor General in Council on any appeal under this section is not duly executed by the proper provincial authority in that behalf, then and in every such case, and as far only as the circumstances of each case require, the Parliament of Canada may make remedial laws for the due execution of the provisions of this section and of any decision of the Governor General in Council under this section. Quebec. Section 93A. Paragraphs 1 to 4 of Section 93 do not apply to Quebec. Subchapter Uniform. We have concluded subchapters on powers of the Parliament, exclusive powers of provincial legislatures, non-renewable natural resources, etc., education. We are now on subchapter Uniformity of laws in Ontario, Nova Scotia, and New Brunswick. Legislation for uniformity of laws in 3 provinces. Notwithstanding anything in this Act, the Parliament of Canada may make provision for the uniformity of all or any of the laws relative to the property and civil rights in Ontario, Nova Scotia, and New Brunswick, and of the procedure of all or any of the courts in those 3 provinces. And from and after the passing of any act in that behalf, the power of the Parliament of Canada to make laws in relation to any matter comprising in any such act shall, notwithstanding anything in this Act, be unrestricted, but any act of the Parliament of Canada making provision for such uniformity shall not have effect in any province, unless and until it is adopted and enacted as a law by the legislature thereof. Subchapter Old Age Pensions. Legislation respecting old age pensions and supplementary benefits. Section 94A. The Parliament of Canada may make laws in relation to old age pensions and supplementary benefits, including survivors and disability benefits, irrespective of age. But no such law shall affect the operation of any law present or future of a provincial legislature in relation to any such matter. Subchapter Agriculture and Immigration. Concurrent powers of legislation respecting agriculture, etc. Section 95. In each province, the legislature may make laws in relation to agriculture in the province and to immigration into the province, and is hereby declared that the Parliament of Canada may from time to time make laws in relation to agriculture in all or any of the provinces, and to immigration into all or any of the provinces, and any law of the legislature of a province related to agriculture or to immigration shall have effect in and for the province as long and as far only as it is not repugnant to any act of the Parliament of Canada. We've now finished Chapter 6, Distribution of Legislative Powers. We are now at Chapter 7, Judicature. Appointment of Judges. Section 96. The Governor General shall appoint the judges of the Superior, District, and County Courts in each province, except those of the Courts of Probate in Nova Scotia and New Brunswick. Selection of judges in Ontario et cetera. Until the laws relative to property and civil rights in Ontario, Nova Scotia, and New Brunswick, and the procedure of the courts in those provinces are made uniform, the judges of the courts of those provinces appointed by the Governor General shall be selected from the respective bars of those provinces. Selection of judges in Quebec. The judges of the courts of Quebec shall be selected from the bar of that province. Tenure of office of judges. Section 99, subsection 1. Subject to subsection 2 of this section, the judges of the superior courts shall hold office during good behavior, but shall be removable by the Governor General on address of the Senate and House of Commons. Termination at age 75. Subsection 2 here. A judge of a superior court, whether appointed before or after the coming into force of this section, shall cease to hold office upon attaining the age of 75 years, or upon the coming into force of this section, if at that time he has already attained that age. Salaries, etc., of judges, section 100. The salaries, allowances, and pensions of the judges of the superior district and county courts, except the courts of probate in Nova Scotia and New Brunswick, and of the Admiralty courts in cases where the judges thereof are for the time being paid by salary, shall be fixed and provided by the Parliament of Canada. General Court of Appeal et cetera. Section 101. The Parliament of Canada may, notwithstanding anything in this Act, from time to time, provide for the constitution, maintenance, and organization of a General Court of Appeal for Canada, and for establishment of any additional courts, for the better administration of the laws of Canada. Chapter 8. Revenues, debts, assets, taxation. Creation of Consolidated Revenue Fund. This is section 102. All duties and revenues over which the respective legislatures of Canada, Nova Scotia, and New Brunswick, before and at the Union, had and have power of appropriation, except such portions thereof as are by this Act reserved for the respective legislatures of the provinces, or are raised by them in accordance with the special powers conferred on them by this Act, shall form one consolidated revenue fund, to be appropriated for the public service of Canada in the manner and subject to the charges in this Act provided. Expenses of collection, etc. The Consolidated Revenue Fund of Canada shall be permanently charged with the costs, charges, and expenses incident to the collection, maintenance, and receipt thereof, and the same shall form the first charge thereon, subject to be reviewed and audited in such manner as shall be ordered by the Governor General in Council until the Parliament otherwise provides. interest of public, or pardon me, interest of provincial public debts. Section 104. The annual interest of the public debts of the several provinces of Canada, Nova Scotia, and New Brunswick at the Union shall form the second charge on the Consolidated Revenue Fund of Canada. Salary of Governor General. Unless altered by the Parliament of Canada, the salary of the Governor General shall be £10,000 sterling money of the United Kingdom of Great Britain and Ireland, payable out of the Consolidated Revenue Fund of Canada, and the same shall form the third charge thereon. Appropriation from time to time. Section 106. Subject to the several payments by this Act charged on the Consolidated Revenue Fund of Canada, the same shall be appropriated by the Parliament of Canada for the public service. Transfer of stocks, etc. All stocks, cash, bankers' balances, and securities for money belonging to each province at the time of the Union, except as in this Act mentioned, shall be the property of Canada and shall be taken in reduction of the amount of the respective debts of the provinces at the Union. Transfer of property in schedule. The public works and property of each province enumerated in the third schedule of this Act shall be the property of Canada. Property in lands, mines, etc. All lands, mines, minerals, and royalties belonging to the several provinces of Canada, Nova Scotia, and New Brunswick at the Union, and all sums then due or payable for such lands, mines, minerals, or royalties shall belong to the several provinces of Ontario, Quebec, Nova Scotia, and New Brunswick, in which the same are situate or arise, subject to any trust existing in respect thereof, and to any interest other than that of the province in the same. We've now reached the end of the page. I am flipping the page. We are now on what appears to be the last page before the schedules. We are in Chapter 8, continuing revenues, debts, assets, taxation. So that's Chapter 8, yes. Assets connected with provincial debts. All assets connected with such portions of the public debt of each province as are assumed by that province shall belong to that province. Canada to be liable for provincial debt. Canada shall be liable for the debts and liabilities of each province existing at the Union. Debts of Ontario and Quebec. Ontario and Quebec co-jointly shall be liable to Canada for the amount, if any, by which the debt of the province of Canada exceeds at the Union $62,500,000 and shall be charged with interest at the rate of 5%, the interest at the rate of 5% per annum thereon. Assets of Ontario and Quebec. The assets enumerated in the fourth schedule to this Act belonging at the Union to the Province of Canada shall be the property of Ontario and Quebec co-jointly. Debt of Nova Scotia. Nova Scotia shall be liable to Canada for the amount, if any, by which its public debt exceeds at the Union $8 million and shall be charged with interest at the rate of 5% per annum thereon. Debt of New Brunswick. New Brunswick shall be liable to Canada for the amount, if any, by which its public debt exceeds at the Union $7 million and shall be charged with interest at the rate of 5% per annum thereon. Payment of interest to Nova Scotia and New Brunswick. In case the public debts of Nova Scotia and New Brunswick do not at the Union amount to $8 million and $7 million respectively, they shall respectively receive by half-yearly payments in advance from the Government of Canada interest at 5% per annum on the difference between the actual amounts of their respective debts and such stipulated amounts. Provincial public property. The several provinces shall retain all their respective public property and not otherwise let's rewind. The several provinces shall retain all their respective public property not otherwise disposed of in this Act, subject to the right of Canada to assume any lands or public property required for fortifications or for the defense of the country. Under this same title, Provincial Public Property, we have Section 18, but it was repealed. Further grant to New Brunswick. New Brunswick shall receive by half-yearly payments in advance from Canada for the period of 10 years from the Union an additional allowance of $63,000 per annum, but as long as the public debt of that province remains under $7 million, a deduction equal to the interest at 5% per annum on such deficiency shall be made from the allowance of $63,000. Form of payments. All payments to be made under this Act, or in discharge of liabilities created under any act of the provinces of Canada, Nova Scotia, and New Brunswick respectively, and assumed by Canada, shall, until the Parliament of Canada otherwise directs, be made in such form and manner as may from time to time be ordered by the Governor-General in Council. Canadian manufacturers. All articles of the growth, produce, and rewinding. This is Section 121. All articles of the growth, produce, or manufacture of any one of the provinces shall, from and after the Union be admitted free into each of the other provinces. Continuance of customs and excise laws. The customs and excise laws of each province shall, subject to the provisions of this Act, continue in force until altered by the Parliament of Canada. Exportation and importation as between two provinces. Where customs duties are at the Union leviable on any goods, wares, or merchandises in any two provinces, those goods, wares, and merchandises may, from and after the Union, be imported from one of those provinces into the other of them on proof of payment of the customs duty leviable thereon in the province of exportation, and on payment of such further amount, if any, of customs duty as is leviable thereon in the province of importation. Lumber dues in New Brunswick. Nothing in this Act shall affect the right of New Brunswick to levy the lumber dues provided in Chapter 15 of Title 3 of the Revised Statutes of New Brunswick, or in any act amending that act before or after the Union, and not increasing the amount of such dues. But the lumber of any of the provinces other than New Brunswick shall not be subject to such dues. Exemption of public lands at Ketera. No lands or property belonging to Canada or any province shall be liable to taxation. Provincial Consolidated Revenue Fund. Such portions of the duties and revenues over which the respective legislatures of Canada, Nova Scotia, and New Brunswick had, before the Union, power of appropriation, as are by this Act reserved to the respective governments or legislatures of the provinces, and all duties and revenues raised by them in accordance with the special powers conferred upon them by this Act, shall, in each province, form one consolidated revenue fund, and to be appropriated for the public service of the province. Here, we now continue from Chapter 8, Revenues, Debts, Assets, Taxation. We go to the next chapter, which is Chapter 9, Miscellaneous Provisions. Subchapter General. Section 127 was repealed. Oath of Allegiance at Ketera. 128 section. Every member of the Senate or House of Commons of Canada shall, before taking his seat therein, take and subscribe before the Governor General or some person authorized by him, and every member of the Legislative Council or Legislative Assembly of any province shall, before taking his seat therein, take and subscribe before the Lieutenant Governor of the province or some person authorized by him the oath of allegiance contained in the 5th schedule of this Act. And every member of the Senate of Canada and every member of the Legislative Council of Quebec shall also, before taking his seat therein, take and subscribe before the Governor General or some person authorized by him the declaration of qualification contained in the same schedule. Continuance of existing laws, courts, officers, etc. Section 129. except as otherwise provided by this law, this act, except as otherwise provided by this act, all laws in force in Canada, Nova Scotia or New Brunswick at the Union, and all courts of civil and criminal jurisdiction, and all legal commissions, powers and authorities, and all officers, judicial, administrative, and ministerial, existing therein at the Union, shall continue in Ontario, Quebec, Nova Scotia, and New Brunswick, respectively, as if the Union had not been made, subject nevertheless, except with respect to such as are enacted by or exist under acts of Parliament of Great Britain or of the Parliament of the United Kingdom of Great Britain and Ireland, to be repealed, abolished, or altered by the Parliament of Canada or by the legislature of the respective province, according to the authority of the Parliament or of that legislature under this Act. Transfer of officers to Canada. Until the Parliament of Canada otherwise provides, all officers of the several provinces having duties to discharge in relation to matters other than those coming within the classes of subjects by this Act assigned exclusively to the legislatures of the provinces, shall be officers of Canada, and shall continue to discharge their duties of their respective offices under the same liabilities, responsibilities, and penalties as if the Union had not been made. Appointment of new officers. Section 131. Until the Parliament of Canada otherwise provides, the Governor-General in Council may, from time to time, appoint such officers as the Governor-General in Council deems necessary or proper for the effectual execution of this Act. Treaty Obligations. Section 132. The Parliament and Government of Canada shall have all powers necessary or proper for performing the obligations of Canada or of any province thereof as part of the British Empire towards foreign countries arising under treaties between the Empire and such foreign countries. Use of English and French languages. Section 133. Either the English or the French language may be used by any person in the debates of the Houses of the Parliament of Canada and of the Houses of the Legislature of Quebec. And both those languages shall be used in the respective records and journals of those houses. And either of those languages may be used by any person or in any pleading or process in or issuing from any court of Canada established under this Act, and in or from all or any of the courts of Quebec. The Acts of the Parliament of Canada and of the Legislature of Quebec shall be printed and published in both these languages. So now we're on Ontario and Quebec, subchapter. Ontario and Quebec under Miscellaneous Provisions, Chapter 9. Appointment of executive officers for Ontario and Quebec. Until the legislature of Ontario or of Quebec otherwise provides, the lieutenant governors of Ontario and Quebec may each appoint under the great seal of the province of the following the following officers to hold office during during pleasure, that is to say, the Attorney General, the Secretary and Registrar of the Province, the Treasurer of the Province, the Commissioner of Crown Lands, and the Commissioner of Agriculture and Public Works. And in the case of Quebec, the Solicitor General, and may, by order of the Lieutenant Governor in Council, from time to time, prescribe the duties of those officers and of the several departments over which they shall preside or to which they shall belong, and of the officers and clerks thereof, and may also appoint other and additional officers to hold office during pleasure, and may from time to time describe the duties of those officers and of the several departments over which they shall preside or to which they shall belong, and of the officers and clerks thereof. Powers, duties, etc. of executive officers. Section 135. Until the legislature of Ontario or Quebec otherwise provides, all rights, powers, duties, functions, responsibilities, or authorities at the passing of this Act vested in or imposed on the Attorney General, Solicitor General, Secretary and Registrar of the Province of Canada, Minister of Finance, Commissioner of Crown Lands, Commissioner of Public Works, and Minister of Agriculture and Receiver General, by any law, statute, or ordinance of Upper Canada, Lower Canada, or Canada, and not repugnant to this Act, shall be vested in or imposed on any officer to be appointed by the Lieutenant Governor for the discharge of the same, or any of them, and the Commissioner of Agriculture and Public Works shall perform the duties and functions of the office of Minister of Agriculture at the passing of this Act, imposed by the law of the Province of Canada, as well as those of the Commissioner of Public Works. Great Seals, Section 136. Until altered by the Lieutenant Governor in Council, the Great Seals of Ontario and Quebec, respectively, shall be the same, or of the same design, as those used in the provinces of Upper Canada and Lower Canada, respectively, before their union as the Province of Canada. Construction of Temporary Acts. 137. The words, and from thence to the end of the then next issuing, rewinding. The words, and then in italics and bold, and from thence to the end of the then next ensuing session of legislature, end bold italics, or words to the same effect, used in any temporary act of the Province of Canada not expired before the Union, shall be construed to extend and apply to the next session of the Parliament of Canada, if the subject matter of the Act is within the powers of the same as defined by this Act, or to the next sessions of the legislatures of Ontario and Quebec respectively, if the subject matter of the Act is within the powers of the same as defined by this Act. As to errors in names. Section 138. From and after the Union, the use of the words Upper Canada instead of Ontario, or Lower Canada instead of Quebec, in any deed, writ, process, pleading, document, matter, or thing, shall not invalidate the same. As to issue of proclamations before Union, to commence after Union. Section 139. Any proclamation under the Great Seal of the Province of Canada issued before the Union to take effect at time which is subsequent to the Union, whether relating to that province or to Upper Canada or to Lower Canada, and the several matters and things therein proclaimed, shall be and continue of like force and effect as if the Union had not been made. As to issue of proclamations after Union. Now, any proclamation which is authorized by any act of the legislature of the Province of Canada shall be issued under the Great Seal of the Province of Canada, whether relating to that province or to Upper Canada or to Lower Canada, and which is not issued before the Union, may be issued by the Lieutenant Governor of Ontario or of Quebec as its subject matter requires, under the Great Seal thereof, and from and after the issue of such proclamation, the same and the several matters and things therein proclaimed shall be and continue of the like force and effect in Ontario and Quebec as if the Union had not been made. Penitentiary. The penitentiary of the Province of Canada shall, until the Parliament of Canada otherwise provides, be and continue the penitentiary of Ontario and Quebec. Arbitration respecting debts, etc. Section 142. The division and adjustment of the debts, credits, liabilities, properties, and assets of Upper Canada and Lower Canada shall be referred to the arbitrament of 3 arbitrators, one chosen by the Government of Ontario, one by the Government of Quebec, and one by the Government of Canada, and the selection of the selection of the arbitrators shall not be made until the Parliament of Canada and the legislatures of Ontario and Quebec have met, and the arbitrator chosen by the Government of Canada shall not be a resident either in Ontario or in Quebec. Division of records. 143. The Governor General in Council may, from time to time, order that such and so many of the records, books, and documents of the Province of Canada as he thinks fit shall be appropriated and delivered either to Ontario or Quebec, and the same shall therefore thenceforth be the property of that province, and any copy thereof or extract therefrom duly certified by the officer having charge of the original thereof shall be admitted as evidence. Constitution of Townships in Quebec, Section 144. The Lieutenant Governor of Quebec may from time to time, by proclamation under the Great Seal of the province, to take effect from a day to be appointed therein, constitute townships in those parts of the province of Quebec in which townships are not then already constituted, and fix the metes and bounds thereof. That was the end of Chapter 9, Miscellaneous Provisions. Chapter 10, Intercolonial Railway, Section 145, repealed. Chapter 11. Admission of other colonies. Power to admit Newfoundland, etc. into the Union. Section 146. It shall be lawful for the Queen, by and with the advice of Her Majesty's most honourable Privy Council, on addresses from the Houses of the Parliament of Canada and from the Houses of the respective legislatures of the colonies or provinces of Newfoundland, Prince Edward Island, and British Columbia, to admit those colonies or provinces or any of them into the Union, and on address from the Houses of the Parliament of Canada to admit Rupert's Land and the Northwest Territory, or either of them, into the Union on such terms and conditions in each case as are in the addresses expressed and as the Queen thinks fit to approve, subject to the provisions of this Act and the provisions of any order in council in that behalf shall have effect as if they had been enacted by the Parliament of the United Kingdom of Great Britain and Ireland. Finally, as to representation of Newfoundland and Prince Edward Island in Senate. In case of the admission of Newfoundland and Prince Edward Island, or either of them, each shall be entitled to a representation in the Senate of Canada of 4 members, and, notwithstanding anything in this Act, in case of the admission of Newfoundland, the normal number of senators shall be 76, and their maximum number shall be 82. But Prince Edward Island, when admitted, shall be deemed to be comprised in the third of the 3 divisions into which Canada is, in relation to the Constitution of the Senate, divided by this Act, and accordingly, after the admission of Prince Edward Island, whether Newfoundland is admitted or not, the representation of Nova Scotia and New Brunswick in the Senate shall, as vacancies occur, be reduced from 12 to 10 members respectively, and the representation of each of those provinces shall not be increased at any time beyond 10, except under the provisions of this Act, for the appointment of 3 or 6 additional senators under the direction of the Queen. Now, that is the end of Section 11, Admission of Other Colonies. Section 147. Now, if we go to the next page, this is the first schedule, which is Electoral Districts of Ontario. Now, this is a bunch of content. This is a bunch of contents that are defining the electoral districts of Ontario. Now, I'm going to take a look through this to see what they are all named, to identify if this is a current list, updated every like a constitutional amendment. I don't know. The first schedule, 78. End note, 78. Spent. See Representation Act. All right. The County of Peterborough, divided into 2 ridings. Northumberland, Grenville, Leeds, Lanark, Middlesex, Lambton, Perth, Wellington. I'm just going through a bunch of these. Okay, just randomly. Addington, Renfrew. Alright, so that's one section. Section 2, Electoral Districts of Quebec, specifically fixed. Provincial Public Works and Property. Canals, Provincial Public Works and Property to be the property of Canada. Canals, public harbours, lighthouses and piers in Sable Island. Steamboats, dredges, and public vessels. Rivers and lake improvements. Railways and railway stocks. Mortgages and other debts due by railway companies. Military roads, custom houses, post offices, and all other public buildings, except such as the Government of Canada appropriate for the use of the provincial legislatures and governments. Property transferred by the Imperial Government and known as ordnance property. Property transferred by the Imperial Government and known as ordnance property. Armories, drill sheds, military clothing, and munitions of war, and lands set apart for general public purposes. It's interesting that this includes clothing, provincial public works, and property to be the property of Canada. Military clothing. Okay, so now what is this, after the end of this 6th schedule, then we get to the end and we go to the next page. Wait. Okay, so now I have completed reading another, let's continue. Let's return back to table of contents. So now I've read the Constitution Act 1867, and it's taken me approximately, well, just under 3 hours, it seems. Okay. 2.5 hours. I think what I will do is conclude this, because the next, so I've, well, now the section goes from, I was reading at a rate of what, 3 hours, so that's probably about 50 an hour. Or no, 2.5. That's 150 minutes. So, and I read about 150, approximately 150. So it's approximately 1 per minute. Now, let's just consider the Constitution Act of 1982 and the Canada Act of 1982 and Constitution Act of 1982, wherein we have a Part 1, which is 34 sections constituting the Canadian Charter of Rights and Freedoms. Let's check this out. Now, the Canada Act here we have sections 1 through 4. This act may be cited as Canada Act 1982. So it only has 4 sections. And then we go into the Constitution Act 1982. Part 1, sections 1 through 34. So there's 1 to 4. That's the Canada Act. Then the 1 to 34 is the Constitutional Act 1984. 1982. Which goes 1 to, I don't even know. It goes up to 52 sections, 52 sections. $34. But then, okay, it says to 61 right here. So that's the next. These are all individual pages. Rights of the Aboriginal peoples. 35 all the way to 61. Amendment, Part 4. Amendment to the Constitution Act 1867. And look, there's no content in there, but there is notes, 1.4. The text of this amendment is set out in the Constitution Act 1867 as Section 92A. The text of this amendment is set out. I see. So it's just saying that it was added in. So those are the sections. These sections define amendments, but wherein that amendment is actually applied to the text as such. Okay. So well, shoot it. I think this is probably pretty easy to go through it on this. Now I've just been reviewing it for a few minutes. Let's continue to check this out. The Canada Act of 1982. Now we have a giant footnote here, nice and bold, 80, or end note. French version enacted as Schedule A to the Canada Act 1982. 1982 C11. I don't know the coding for that, what this actually means. An act to give effect to a request by the Senate and House of Commons of Canada. Whereas Canada has requested and consented to the enactment of an act of the Parliament of the United Kingdom to give effect to the provisions herein after set forth, and the Senate and the House of Commons of Canada in Parliament assembled have submitted an address to Her Majesty requesting that Her Majesty may graciously be pleased to cause a bill to be laid before the Parliament of the United Kingdom for that purpose. Be it therefore enacted by the Queen's most excellent Majesty, by and with the advice and consent of the Lords spiritual and temporal and Commons in this present Parliament assembled, and by the authority of the same, as follows. 1. The Constitution Act 1982, set out in Section B to this Act, is hereby enacted for and shall have the force of law in Canada and shall come into force as provided in that Act. 2. The next section. These are sections, but I don't have to enumerate them. No act of the Parliament of the United Kingdom passed after the Constitution Act 1982 comes into force shall extend to Canada as part of its law. So far as it is not contained in Section B, the French version of this Act is set out in Section A to this Act, and has the same authority in Canada as the English version thereof. This Act may be cited as Canada Act 1982. Constitution Act 1982. Part 1. Canadian Charter of Rights and Freedoms. Whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. Guarantee of rights and freedoms. This is chapter 1, or pardon me, subchapter, guarantee of rights and freedoms. Rights and freedoms in Canada. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Subchapter Fundamental Freedoms. Fundamental freedoms. Everyone has the following fundamental freedoms. A. Freedom of conscience and religion. 2. B. Freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. C. Freedom of peaceful assembly. And D. Freedom of association. Subchapter Democratic Rights. Democratic rights of citizens. Every citizen of Canada has the right to vote in an election of members of the House of Commons or of a legislative assembly, and to be qualified for membership therein. Maximum duration of legislative bodies. Section 4, subsection 1. No House of Commons and no legislative assembly shall continue for longer than 5 years from the date fixed for the return of the writs of a general election of its members. Continuation in special circumstances. Section 4, subsection 2. In time of real or apprehended war, invasion, or insurrection, a House of Commons may be continued by Parliament, and a legislative assembly may be continued by the legislature beyond 5 years if such continuation is not opposed by the votes of more than 1/3 of the members of the House of Commons or the Legislative Assembly, as the case may be. Annual sitting of legislative bodies. Section 5. There shall be a sitting of Parliament and of each legislature at least once every 12 months. Subchapter Mobility Rights. Mobility of citizens. Section 6, subsection 1. Every citizen of Canada has the right to enter, remain in, and leave Canada. Rights to move and gain livelihood. Section 6, subsection 2. Every citizen of Canada and every person who has the status of a permanent resident of Canada has the right: A. To move to and take up residence in any province, and B. To pursue the gaining of a livelihood in any province. Limitation. Section 6, subsection 3. The rights specified in subsection 2 are subject to a. Any laws or practices of general application in force in a province or other than those that discriminate among people primarily on the basis of provincial or present rewinding. Any laws or practices of general application in force in a province other than those that discriminate among persons primarily on the basis of province of present or previous residence, and b. any laws providing for reasonable residency requirements as a qualification for the receipt of publicly provided social services. Affirmative action programs. Section 6, subsection 4. Subsections 2 and 3 do not preclude any law, program, or activity that has as its object the amelioration in a province of conditions of individuals in that province who are socially or economically disadvantaged if the rate of employment in that province is below the rate of employment in Canada. Subchapter Legal Rights. Life, liberty, and security of person. Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. Search and seizure. Section 8. Everyone has the right to be secure against unreasonable search and seizure, detention, or imprisonment. Everyone has the right not to be arbitrarily detained or imprisoned. Arrest or detention. Everyone has the right on arrest or detention, a. to be informed promptly of the reasons therefor, b. to retain and instruct counsel without delay and to be informed of that right, and c. to have the validity of the detention determined by way of habeas corpus and to be released if the detention is not lawful. Proceedings in criminal and penal matters. Section 11. Any person charged with an offense has the right, a. to be informed without unreasonable delay of the specific offense, b. to be tried within a reasonable time, c. not to be compelled to be a witness in proceedings against that person in respect of the offense, d. to be presumed innocent until proven guilty according to law in a fair and public hearing by an independent and impartial tribunal, e. not to be denied reasonable bail without just cause, f. except in the case of an offense under military law tried before a military tribunal to the benefit of trial by jury where the maximum punishment for the offense is imprisonment for 5 years or a more severe punishment. G. Not to be found guilty on account of any act or omission unless at the time of the act or omission it constituted an offense under Canadian or international law or was criminal according to the general principles of law recognized by the community of nations. H. If finally acquitted of the offense, not to be tried for it again, and if finally found guilty and punished for the offense, not to be tried or punished for it again. And I, if found guilty of the offense, and if the punishment for the offense has been varied between the time of the commission and the time of the sentencing, the benefit of the lesser punishment. Treatment or punishment. Section 12. Everyone has the right not to be subjugated to any cruel or unusual treatment or punishment. Self-crimination. Section 13. A witness who testifies in any proceedings has the right not to have any incriminating evidence so given used to incriminate that witness in any other proceedings, except in a prosecution for perjury or for the giving of contradictory evidence. Interpreter. Section 14. A party or witness in any proceedings who does not understand or speak the language in which the proceedings are conducted, or who is deaf, has the right to the assistance of an interpreter. Subchapter Equality Rights. Equality before and under law, and equal protection and benefit of law. Section 15, subsection 1. Every individual is equal before and under the law, and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, mental or physical disability. Affirmative action programs. Section 15, subsection 2. Subsection 1 does not preclude any law, program, or activity that has as its object the amelioration of conditions of disadvantaged individuals or groups, including those that are disadvantaged because of race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Subchapter Official Languages of Canada. Official Languages of Canada. Section 16, subsection 1. English and French are the official languages of Canada and have equality of status and equal rights and privileges as to their use in all institutions of the Parliament and Government of Canada. Official languages of New Brunswick. Subsection 2. English and French are the official languages of New Brunswick and have equality of status and equal rights and privileges as to their use in all institutions of the legislature and government of New Brunswick. Advancement of status and use. Subsection 3. Nothing in this charter limits the authority of Parliament or a legislature to advance the equality of status or use of English and French. English and French linguistic communities in New Brunswick. Section 16.1, subsection 1. The English linguistic community and the French linguistic community in New Brunswick have equality of status and equal rights and privileges, including the right to distinct educational institutions. and such distinct cultural institutions as are necessary for the preservation and promotion of those communities. Role of the legislature and government of New Brunswick. Section 16.1, subsection 2. The role of the legislature and government of New Brunswick to preserve and promote the status, rights, and privileges referred to in subsection 1 is affirmed. Proceedings of Parliament. Section 17. Subsection 1. Everyone has the right to use English or French in any debates and other proceedings of Parliament. Proceedings of New Brunswick Legislature. Section 17, subsection 2. Everyone has the right to use English or French in any debates and other proceedings of the legislature of New Brunswick. Parliamentary statutes and records. Section 18, subsection 1. The statutes, records, and journals of Parliament shall be printed and published in English and French, and both language versions are equally authoritative. New Brunswick statutes and records. Section 18, subsection 2. The statutes, records, and journals of the legislature of New Brunswick shall be printed and published in English and French, and both language versions are equally authoritative. Proceedings in courts established by Parliament. 19, subsection 1. Either French or English may be used by any person in or in any pleading in or process issuing from any court established by Parliament. Proceedings in New Brunswick courts. Subsection 2. Either English or French may be used by any person in or in any pleading in or process issuing from any court of New Brunswick. Communications by public with federal institutions. Section 20, subsection 1. Any member of the public in Canada has the right to communicate with and to receive available services from and any head or central office of any institution of the Parliament or Government of Canada. In French or in English or French, and has the same right with respect to any other office of any such institution where A, there is a significant demand for communications with and services from that office in such language, or B, due to the nature of the office, it is reasonable that communications with and services from that office be available in both English and French. Communications by public with New Brunswick institutions. Subsection 2. Any member of the public in New Brunswick has the right to communicate with and to receive available services from any office of an institution of the legislature or government of New Brunswick in English or French. Continuation of existing constitutional provisions. Section 21. Nothing in sections 16 to 20 abrogates or derogates from any right, privilege, or obligation with respect to the English and French languages, or either of them, that exists or is continued by virtue of any other provision of the Constitution of Canada. Rights and privileges preserved. Section 22. Nothing in sections 16 to 20 abrogates or derogates from any legal or customary right or privilege acquired or enjoyed either before or after the coming into force of this charter with respect to any language that is not English or French. Subchapter Minority Language Educational Rights. Language of instruction. Section 23. Subsection 1. Citizens of Canada, A, whose first language learned and still understood is that of the English or French linguistic minority population of the province in which they reside, or B, who have received their primary school instruction in Canada in English or French and reside in a province where the language in which they receive that instruction is the language of the English or French linguistic minority population of the province, have the right to have their children receive primary and secondary school instruction in that language in that province. Continuity of language instruction. Subsection 2. Citizens of Canada of whom any child has received or is receiving primary or secondary school instruction in English or French in Canada have the right to have all their children receive primary and secondary school instruction in the same language. Application where numbers warrant. Subsection 3. The right of citizens of Canada under subsections 1 and 2 to have their children receive primary and secondary school instruction in the language of the French or English linguistic minority population of a province, A, applies wherever in the province the number of children of citizens who have such a right is sufficient to warrant the provision to them out of public funds of minority language instruction, and B, includes where the number of those children so warrants the right to have them receive that instruction in minority language educational facilities provided out of public funds. Subchapter Enforcement. Enforcement and guarantee of rights and freedoms. Section 24, subsection 1. Anyone whose rights or freedoms as guaranteed by this charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. May apply. Exclusion of the evidence bringing administration of justice into dispute. Subsection 2. Where, in proceedings under subsection 1, a court concludes that evidence was obtained in a manner that infringed or denied any rights or freedoms guaranteed by this charter, the evidence shall be excluded if it is established that, having regard to all the circumstances, the admission of it in the proceedings would bring the administration of justice into disrepute. Subchapter General. Aboriginal rights and freedoms not affected by the Charter. Section 25. The guarantee in this Charter of certain rights and freedoms shall not be construed so as to abrogate or derogate from any Aboriginal treaty or other rights or freedoms that pertain to the Aboriginal peoples of Canada, including A, any rights or freedoms that have been recognized by the Royal Proclamation of October 7, 1763, and B, any rights or freedoms that now exist by way of land claims agreements or maybe so acquired. Other rights and freedoms not affected by the Charter. 26. The guarantee in this Charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada. Multicultural heritage. Section 27. This Charter shall be interpreted in a manner consistent with the preservation and enhancement of the multicultural heritage of Canadians. Rights guaranteed equally to both sexes, notwithstanding anything in this Charter. The rights and freedoms referred to in it are guaranteed equally to male and female persons. Rights respecting certain schools preserved. Nothing in this Charter abrogates or derogates from any rights or privileges guaranteed by or under the Constitution of Canada in respect to denominational, separate, or dissentient schools. Application to territories and territorial authorities. A reference in this Charter to a province or to the Legislative Assembly or legislature of a province shall be deemed to include a reference to the Yukon Territory and the Northwest Territories or to the appropriate legislative authority thereof, as the case may be. Legislative powers not extended. Nothing in this Charter extends the legislative powers of any body or authority. Subchapter or application of Charter. Application of Charter. 32, Section 32, subsection 1. This Charter applies A. to the Parliament and Government of Canada in respect to all matters within the authority of Parliament, including all matters relating to the Yukon Territory and Northwest Territories, and B. to the legislature and government of each province in respect to all matters within the authority of the legislature of each province. Exception. Subsection 2. Notwithstanding subsection 1, Section 15 shall not have effect until 3 years after this section comes into force. Section 15. Equality rights and affirmative action programs. Exception where express declaration. 33 subsection 1. Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or a provision thereof shall operate, notwithstanding a provision included in Section 2 or Section 7 to 15 of this Charter. Operation of exception. Subsection 2. An act or a provision of an act in respect of which a declaration made under this section is in effect, shall have such operation as it would have but for the provision of this Charter referred to in the declaration. 5-year limitation. subsection 3. A declaration made under subsection 1 shall cease to have effect 5 years after it comes into force, or on such earlier date as may be specified in the declaration. Reenactment, subsection 4. Parliament or the legislature of a province may reenact a declaration made under subsection 1. 5-year limitation, subsection 5. Subsection 3 applies in respect of a reenactment made under subsection 4. Subchapter citation. Section 34. This part may be cited as the Canadian Charter of Rights and Freedoms. Okay, we are at the final section of the final page of the main body of the Constitution Act of 1982. This is part 2, and here we find part 2 is rights of the Aboriginal peoples of Canada. Recognition of existing Aboriginal and treaty rights. 35, subsection 1. The existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Definition of Aboriginal peoples of Canada. Subsection 2. In this act, Aboriginal peoples of Canada includes the Indian, Inuit, and Métis peoples of Canada. Land claims agreements. Subsection 3. For greater certainty, in subsection 1, treaty rights includes rights that now exist by way of land claims agreements, or may be so acquired. Aboriginal and treaty rights are guaranteed equally to both sexes. Subsection 4. Notwithstanding any other provision of this Act, the Aboriginal and treaty rights referred to in subsection 1 are guaranteed equally to male and female persons. Commitment to participation in constitutional conference. Section 35.1. The government of Canada and the provincial governments are committed to the principle that before any amendment is made to Class 24 of Section 91 of the Constitution Act 1867 to Section 35 of this Act, or to this part, A, a constitutional conference that includes in its agenda an item related to the proposed amendment composed of the Prime Minister of Canada and the First Ministers of the provinces shall be convened by the Prime Minister of Canada, and B, the Prime Minister of Canada will invite representatives of the Aboriginal peoples of Canada to participate in the discussions on that item. Part 3. Equalization and regional disparities. Commitment to promote equal opportunities. 36. Subsection 1. Without altering the legislative authority of Parliament or of the provincial legislatures, or the rights of any of them with respect to the exercise of their legislative authority, Parliament and the legislatures, together with the Government of Canada and the provincial governments, are committed to a. Promoting equal opportunities for the well-being of Canadians, b. Furthering economic development to reduce disparity in opportunities, and c. Providing essential public services of reasonable quality to all Canadians. Commitment respecting public services. Subsection 2. Parliament and the Government of Canada are committed to the principle of making equalization payments to ensure that provincial governments have sufficient revenues to provide reasonably comparable levels of public services at reasonably comparable levels of taxation. Part 4. Constitutional Conference. Section 37, repealed. Part 4. Subpart 1. Constitutional Conferences. Section 37.1. Repealed. Part 5. Procedure for amending Constitution of Canada. General procedure for amending Constitution of Canada. Section 38, subsection 1. An amendment to the Constitution of Canada may be made by proclamation issued by the Governor General under the Great Seal of Canada, where so authorized by a. Resolutions of the Senate and House of Commons, and b. Resolutions of the legislative assemblies of at least 2/3 of the provinces that have, in the aggregate, according to the then latest general census, at least 50% of the population of all the provinces. Majority of members. Section 38, subsection 2. An amendment made under subsection 1 that derogates from the legislative powers, the proprietary rights, or any other rights or privileges of the legislature or government of a province shall require a resolution supported by a majority of the members of each of the Senate, the House of Commons, and the legislative assemblies required under subsection 1. Expression of dissent, subsection 3. An amendment referred to in subsection 2 shall not have effect in a province the legislative assembly of which has expressed its dissent thereto by resolution supported by a majority of its members prior to the issue of the proclamation to which the amendment relates, unless that legislative assembly subsequently, by resolution supported by a majority of its members, revokes its dissent and authorizes the amendment. Revocation of dissent. Subsection 4. A resolution of dissent made for the purposes of subsection 3 may be revoked at any time before or after the issue of the proclamation to which it relates. Restriction on proclamation. Section 39, subsection 1. A proclamation shall not be issued under subsection 38. Subsection 38 Section 38, subsection 1, before the expiration of 1 year from the adoption of the resolution initiating the amendment procedure thereunder, unless the Legislative Assembly of each province has previously adopted a resolution of assent or dissent. Idem. Subsection 2. A proclamation shall not be issued under Section 38, subsection 1, after the expiration of 3 years from the adoption of the resolution initiating the amendment procedure thereunder. Compensation. Section 40. Where an amendment is made under 38.1 that transfers provincial legislative powers relating to education or other cultural matters from provincial legislatures to Parliament, Canada shall provide reasonable compensation to any province to which the amendment does not apply. Amendment by unanimous consent. An amendment to the Constitution of Canada in relation to the following matters may be made by proclamation issued by the Governor-General under the Great Seal of Canada, only where authorized by resolutions of the Senate and House of Commons and of the Legislative Assembly of each province. A. The office of the Queen, the Governor-General, and the Lieutenant Governor of a province. B. The right of a province to a number of members in the House of Commons not less than the number of senators by which the province is entitled to be represented at the time this part comes into force. C. Subject to Section 43, the use of the English or the French language. D. The composition of the Supreme Court of Canada. And E. An amendment to this part. Amendment by general procedure. Section 42, subsection 1. An amendment to the Constitution of Canada in relation to the following matters may be made only in accordance with Section 38, subsection 1. A. The principle of proportionate representation of the provinces in the House of Commons prescribed by the Constitution of Canada. B. The powers of the Senate and the method of selecting senators. C. The number of members by which a province is entitled to be represented in the Senate and the residence qualifications of senators. D. Subject to paragraph 41D, the Supreme Court of Canada. E. The extension of existing provinces into the territories. And F. Notwithstanding any other law or practice, the establishment of new provinces. Exception. Subsection 2. Subsections 38 to 4 do not apply in respect of amendments in relation to matters referred to in subsection 1. An amendment of provisions relating to some but not all provinces. Section 43. An amendment to the Constitution of Canada in relation to any provision that applies to one or more but not all provinces, including A. Any alteration to boundaries between provinces, and B. Any amendment to any provision that relates to the use of the English or French language within a province. may be made by proclamation issued by the Governor General under the Great Seal of Canada only where so authorized by resolutions of the Senate and House of Commons and of the Legislative Assembly of each province to which the amendment applies. Amendments by Parliament. Section 44. Subject to sections 41 and 42, Parliament may exclusively make laws amending the Constitution of Canada in relation to the Executive Government of Canada or the Senate and House of Commons. Amendments by provincial legislatures. Section 45. Subject to Section 41, the legislature of each province may exclusively make laws amending the Constitution of the province. Initiation of amendment procedures. 46, subsection 1. The procedures for amendment under sections 38, 41, 42, and 43 may be initiated either by the Senate or the House of Commons, or by the Legislative Assembly of a province. Revocation of authorization. 46, subsection 2. A resolution of assent made for the purposes of this part may be revoked at any time before the issue of a proclamation authorized by it. Amendments without Senate resolution. 47, subsection 1. An amendment to the Constitution of Canada may be proclaimed under section 38, 41, 42, or 43. May be made without a resolution of the Senate authorizing the issue of the proclamation of it within 180 days after the adoption by the House of Commons of a resolution authorizing its issue. The Senate has not adopted such a resolution, and if at any time after the expiration of that period the House of Commons again adopts the resolution. Computation of period. 47, section 2, subsection 2. Any period when Parliament is prorogued or dissolved shall not be counted in computing the 180-day period referred to in subsection 1. Advice to issue proclamation. Section 48. The Queen's Privy Council for Canada shall advise the Governor-General to issue a proclamation under this part forthwith on the adoption of the resolutions required for an amendment made by proclamation under this part. Constitutional Conference. A constitutional conference composed of the Prime Minister of Canada and the First Ministers of the provinces shall be convened by the Prime Minister of Canada within 15 years after this part comes into force to review the provisions of this part. Part 6. Amendment to the Constitution Act 1867. Now here we have two sections, 50 and 51, of which the text is actually, the point of these are to say that the text is being applied. Let's just confirm that was 104, and note 105. The text of this amendment is set out in the Constitution Act 1867 as the 6th schedule. Indeed. Part 7, General. Primacy of Constitution of Canada. Section 52, subsection 1. The Constitution of Canada is the supreme law of Canada. and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. Constitution of Canada. Subsection 2. The Constitution of Canada includes A. The Canada Act 1982, including this Act. B. The acts and orders referred to in the schedule. And C. Any amendment to any act or order referred to in paragraph A or B. Amendments to Constitution of Canada. Subsection 3. Section 52, subsection 3. Amendments to the Constitution of Canada shall be made only in accordance with the authority contained in the Constitution of Canada. Repeals and new names. Section 53, subsection 1. The enactments referred to in column 1 of the schedule are hereby repealed or amended to the extent indicated in column 2 thereof, and, unless repealed, shall continue as law in Canada unless under the name set out in column 3 thereof. Consequential amendments, subsection 2. Every enactment except the Canada Act 1982 that refers to an enactment referred to in the schedule by the name in column 1 thereof is hereby amended by substituting for that name the corresponding name in column 3 thereof. And any British North America Act not referred to in this schedule may be cited as the Constitution Act, followed by the year and number, if any, of its enactment. Repeal and consequential amendments. Section 54. Part 4 is repealed on the day that is 1 year after this part comes into force, and this section may be repealed as this act renumbered. Consequently, upon the repeal of Part 4 and this section, by proclamation issued by the Governor General under the Great Seal of Canada. 54, subsection 1, repealed. 55, French version of Constitution of Canada. 55. A French version of the portions of the Constitution of Canada referred to in the schedule shall be prepared by the Minister of Justice of Canada as expeditiously as possible, and when any portion thereof sufficient to warrant action being taken has been so prepared, it shall be put forward for enactment by proclamation issued by the Governor General under the Great Seal of Canada, pursuant to the procedure then applicable to an amendment of the same provisions of the Constitution of Canada. English and French versions of certain constitutional texts. 56. Where any portion of the Constitution of Canada has been or is enacted in French and English, or where a French version of any portion of the Constitution is enacted pursuant to Section 55, the English and French versions of that portion of the Constitution are equally authoritative. English and French versions of this Act The English and French versions of this act are equally authoritative. Commencement 58. Subject to Section 59, this act shall come into force on a day to be fixed by proclamation issued by the Queen or the Governor-General under the Great Seal of Canada. Commencement of paragraph 23, subsection 1A, in respect to Quebec. Section 59, 1, subsection 1. Paragraph 23, subsection 1A, shall come into force in respect of Quebec on a day to be fixed by proclamation issued by the Queen or the Governor-General under the Great Seal of Canada. Authorization of Quebec. Subsection 2. A proclamation under subsection 1 shall be issued only where authorized by the Legislative Assembly or Government of Quebec. Repeal of this section. Subsection 3. This section may be repealed on the day paragraph 23 subsection 1A comes into force in Quebec, comes into force in respect of Quebec, and this act amended and renumbered. Consequently, upon the repeal of this section, by proclamation issued by the Queen or the Governor-General under the Great Seal of Canada. Short title and citations. Section 60. This act may be cited as the Constitution Act 1982 and the Constitution Acts 1867 to 1975, number 2, and this act may be cited together as the Constitution Acts 1867 to 1982. A reference to the Constitution Acts 1967 to 1982 shall be deemed to include a reference to the Constitution Amendment Proclamation 1983. Is that actually contained at the end here? Schedule of to the Constitution Act. Now, that's interesting. 111. Section 61 was added by the Constitution Amendment Proclamation 1983. So also Section 3 of the Constitution Act 1985 SC 1986 Part C8 Part 1 and the Constitution Amendment 1987 Newfoundland Act. Constitution Amendment. All right. I accomplished this in 3 hours and 40 minutes. I have my nice little candle up there burning away. I think I'm going to call this a recording. So we've got to the end, the Constitution, we've done the General, and we've noted that there's a bunch of included parts and amendments and this has been amended since to include an additional. The Constitutional Acts includes the Constitutional Amendment Proclamation of 1983 and a bunch of others that are modifiers in here. Well, that's a chunk. So that's a useful resource now.